So thank you, everyone. Most appreciative of the folks who organized this event. I work in the United States, and sometimes it feels like a silo, and in the last 3 months, it has felt like a horrible silo. So being with folks across borders who are all working to serve survivors is quite refreshing, and really today has been truly inspiring. I loved my lunch conversation. I loved the discussions this morning. I'm so grateful for being fed while I was here. So thank you for all of it. I'm going to take a little bit of time to do some history within the United States, and then get to where are we right now with victims' rights. But before I do that, I want to ground everyone in my approach to things, because I think the one's upbringing, one's training, one's discipline affects the way they approach victim services. I am a lawyer by trade, and I have, again, put brackets around the last 3 months in the United States. I have a deep faith in the justice system. I have a deep faith that law can be a tool of good for people affected by systems. I have done defense work in my legal career, and now I represent victims of crime as my full-time job through the National Crime Victim Law Institute. The Institute, similarly, is a group of lawyers. We are lawyers who came into being in the year 2000 in the United States as an NGO, because what we were observing in the United States was that despite passage of victims' rights laws, our criminal justice system was still causing harm to survivors. And so the founder of the organization, Professor Doug Balloof, was trying to figure out, he was a former prosecutor, he was trying to figure out what else could the system have that might be able to aid victims so that they didn't experience as much, not completely erased, but as much re-victimization from the system. And he founded NCVLI to be lawyers for victims in the criminal case with regard to their rights. Not civil lawsuits, not torts. And so that's the frame from which I come to things, and my entire agency's 25 years has been trying to figure out not the question, can victims have lawyers in a common law criminal justice system, but instead, how can we effectively have lawyers? Because we rejected the premise from the start that victims couldn't have their own lawyers to protect their rights in the criminal case in a common law country, because we've seen that other non-parties can have lawyers and have rights in the system. So I share that with you because I'm going to talk about cases later that are about the work we do representing victims. So a brief history of rights within the United States. Very much like what was shared earlier when we were talking about the British system. In the United States, our colonial history drew from both the British and the Dutch systems when we were colonized, and those systems took root in the United States, even during colonial moments, and then post-revolution and ratification and adoption of our Constitution. Those were the two systems that influenced our legal system the most. And in both of those systems, as we heard this morning, there was a legacy of victim participation that started from some level of victim as both law enforcement and prosecutor, and then coexisted with prosecution once public prosecution arose in the US. So in our system, during the colonies, during the time of our revolution separating from the United Kingdom, and all the way through ratification and adoption of our domestic constitution, victims had a legal role in the well of the court. They brought their own cases and could prosecute them. That was the system all the way up until around the 1970s in the United States, when it was finally clear that that had been so eroded that was like a dream. It had been eroded so much. But what I say on this slide is important. That history was for some victims. It was within the United States for white men. They could be victims and bring cases in court because people of color were generally not recognized in the United States. We have a deep racist history, and particularly Black people in the United States were not recognized as full people under our law. And women could not be victims of most crimes historically. And so this deep tradition in the United States where victims could be in the well of the court started to erode, right? And they started to be pushed behind the bar and become observers of criminal justice, right? Witnesses to their own victimization, witnesses in the case, right? While this public narrative, this public storytelling was happening in the well, and they were merely evidence in their own case. That erosion was happening from the late 1800s. It's really started happening, but all the way through in the early 1900s, all the way through 1920s, it was pretty eroded. And then in the 1970s in the US, you can find these moments where it's just so clear that victims have no legal status in the criminal justice system other than that of piece of evidence, witness. And that led to a grassroots movement across the country that brought together very divergent other social movements to start to reflect on how can we change our system. And on the screen, right, we have the quote from Trauma and Recovery, Dr. Judith Herman's earlier book. She's released a more recent one, of course, talking about if one set out to intentionally design a system for provoking symptoms of post-traumatic stress disorder, it might look very much like a court of law. That recognition that the exclusion of victims and the way they were treated in our criminal justice system was leading to trauma, plus the recognition that that trauma was leading victims in the US to turn away from criminal justice rather than to report, right? Which diminishes the criminal justice system if what it is about is holding people accountable and lifting up societal norms of what is and isn't acceptable behavior. Those two things came together, and in the late 1970s, these social movement groups came together and said, what can we do? And among the things that they thought they could do was pass laws, right? In the early 1980s, our then President Ronald Reagan actually had a task force on this issue, and all of that led to basically a national movement to pass laws in our country that afforded victims' rights. Those laws started to happen at the state level first, right? We have a system where our federal government, right, passes laws out of Congress, but each of our 50 states passes their own. And our federal laws only govern things that happen in federal court, which very few criminal cases move through our federal courts. That is important to remember. Our Constitution governs everything, but our federal statutes, and I'm going to talk about both federal and state statutes in a minute, are limited. So this massive movement happened all across the country. Laws were passed to afford rights and services, and the idea of representation started to be born. I have an article coming out where I trace the history of the idea of lawyers for victims. But bottom line, across the United States, we passed into law almost everywhere at least the statutory level, if not the state constitutional level, which is our highest law within a state, rights that look very much like what's on the screen. The right to be notified of things, to dignity, to due process, to be present, to be heard. Very much like your Bill of Rights, right? These were passed at the state level in the 1980s, and they sat there. Other than in the state of Arizona, where there were lawyers for victims. But the majority of these sat on our books as just words on paper. Not a lot happening with them. If you were lucky enough to have a great prosecutor, we heard from one earlier who talked about trying to be inclusive and really talk to survivors. A survivor in the 80s and 90s in the US might have had a good experience and the rights might have been meaningful. But just down the street, you would be in front of a different prosecutor or a different judge and the rights would mean nothing, right? And part of that was how we had drafted them. We had drafted them with a lot of permissive discretionary language. They were guidance, right? We used may instead of shall. In our tradition, may is the permissive, shall is the mandatory. We used discretionary language that really turned to the prosecutor and said, to the best of your ability, give this right. And so if you had a good prosecutor, they did everything in their ability. But if you had a prosecutor who was juggling too much, maybe it wasn't malfeasance, but they were busy, they had a limited budget, or maybe it was malfeasance. They didn't like the victim. No rights would matter. So starting in the mid-90s, the conversation really started to grow of how do we normalize and equalize rights for victims all across the country. And that is when we started to have the very serious conversation about constitutionalizing rights for victims in the United States. That idea had first been articulated in 1984 by President Ronald Reagan's task force, the National Task Force, but it didn't take root. The conversation was, let's do statutes first. In 1996, President Clinton, who opposed every constitutional amendment, actually supported the notion of constitutionalizing victims' rights. And from 1996 until 2004, our Congress, our US Congress, every year except one, had a victims' rights amendment introduced to consider. Never moved. But in 2004, it came close to moving. And what that means is the people who opposed it at the congressional level finally came to the table to negotiate. Because if you're about to get the possibility of a constitutional amendment and you don't want that, you're willing to negotiate a stronger statute. And that's what happened in 2004. We passed a federal statute affording victims' rights called the Federal Crime Victims' Rights Act. It is actually, that's what in most academic literature, that's what you're going to see it called, the Federal Crime Victims' Rights Act. But what it really is the Scott Campbell, Stephanie Roper, Wendy Preston, Luarna Gillis, and Nyla Lynn Crime Victims' Rights Act. Those are the individuals who were murdered, whose families helped get the law passed. And that matters because it's still a grassroots movement in the US to get anything done. And the rights are the same as the ones that were up on the tree, but now we have them at a federal level, and there's different, even though at our federal level, fewer crimes move through our federal courts, more attention is paid to what happens in our federal courts. More media attention, more money, right? So we started to think, we can start to make these rights more meaningful. But what was unique in this law, I'm going to go back for a second, is the way it was written. There is, with intention, an apostrophe on victims' rights. And that shows up throughout the legislative history of this provision. And it matters because in the US, as and many of you know, is a very individualistic society. And individual rights, we like within our first 2 years start saying, isn't that my right? Like even when we're toddlers, I think. Because we're just so inculcated to the notion that we should have individual rights. And because that is both our popular culture, it is also our legal culture. Ownership of rights dictates a lot in our legal system. So the apostrophe, which denotes ownership of rights, matters. If you write it without the apostrophe, victim is kind of like an adjective on rights. But if you include the apostrophe, that individual owns the right. And under our jurisprudence, before you do anything to infringe upon someone's right if they own it, you have to ask them, what would you like to have done with this right? Do you want to waive it? Do you want to assert it? So it was the start of including people as victims into a legal discourse with intention. And there were a lot of innovative moments in the drafting of the Federal Crime Victims' Rights Act. It includes explicit standing, meaning it says the victim or the prosecuting attorney or a lawyer for the victim can assert the rights of the victim in the trial court. It then goes on to say, and if the trial court doesn't abide those rights, the victim can seek what's known as a writ of mandamus. It's just an old appellate device. It's a way to get to an appellate court to say, wait, my right was violated. And then it also affirmatively, it being the Federal Crime Victims' Rights Act, put an affirmative duty on our judiciary to ensure the rights were afforded. Those are innovative drafting moments. Now, what I will say, because I was involved in drafting, what I will say is they are innovative drafting moments that I abhor. I abhor them because you shouldn't need to say you have standing to assert a right, and if that right is denied, you can seek appeal, and that our judiciary should ensure that the rights of human beings in front of it are abided, that their rights are abided. Because at least in US jurisprudence, we don't say that explicitly about an accused right. We say the accused has a right to confrontation. The accused has a right to fair trial. And then our jurisprudence has taught us, well, of course, they have standing to assert those, and they can seek appellate review if that is denied. And our judiciary should take note of those rights and have systems in place. But the 25-year history of victims' rights in the US said explicit drafting matters because we're bumping up against a culture of exclusion of the victim. And so to break through that cultural barrier, sometimes you have to be explicit. And so that's how we drafted. And so early cases, I wanted to just flag a couple of cases of interest, both 2 from the federal system and then 2 from states, that show what we have been doing with these. And in every case I share, the victim had their own lawyer who helped raise the victim's rights issue and seek redress in the court during the criminal case. Again, this is not about suing anyone in tort for money. This is about ensuring that the participatory right of the victim is integrated in the moment and that proceedings do not go forward if the right of the victim is being violated, that instead we adjust our procedure. So the first case came out very quickly after we passed our Federal Crime Victims' Rights Act. That was Kenna versus US District Court. Note that it is Kenna is the name of the person that is the victim in the case who chose to go by his name. It was a fraud case. And the case is being brought against the district court, not the defendant, because it was not the defendant who violated the victim's rights here. It was not the prosecutor that violated the victim's right. It was the court that violated the victim's right to be heard at sentencing by proceeding without letting Mr. Kenna be heard. And so what happened was Mr. Kenna, the sentencing proceeded. There was a sentencing of a defendant. Mr. Kenna had a right to be heard under the Federal Crime Victims' Rights Act. It was not honored. He left the proceeding. The US attorney, the prosecutor, and an advocate encouraged him to find a lawyer to seek appellate review because they didn't have the resources to do it. We helped him find a no-cost lawyer. He appealed to the appellate court to say that sentencing proceeding was illegal because it did not abide my rights. And the appellate court agreed and struck the sentence, and it actually remanded it and made the trial court strike, but that's like a little really fun if you're a lawyer in the room, right? This dorky little fun lawyer moment. But for everyone else, basically what they said is, yeah, you can't have a sentencing in violation of victims' rights, it has to be undone. He gets a do-over. You get another sentencing proceeding. And it was upheld despite double jeopardy, which is a protection we have in the US, right? And in many common law countries. BP Petroleum, so that was sentencing. BP Petroleum is a more recent case, right? But still pretty early in the movement of making the rights enforceable. But in that case, the prosecution and BP Petroleum, who was the defendant, they had a massive gas explosion. So many people were impacted. Anyone very close by was definitely going to have an increased cancer risk. Their property was damaged. Property values were damaged. But what happened was the prosecutor and the defense, BP's lawyers, started to negotiate before charges were even filed. And then they negotiated down so that the charges would be relatively minor. The monies that would go to the victims would be almost non-existent. Instead, they'd pay a fine into a fund, but individual victims wouldn't get very much. And so that's what we call charge bargaining instead of plea bargaining. They bargained it all, and then they went before court, and they did the charges and the plea, and they were wanted to move to sentencing all the same day. And the victims learn about this along with the rest of the public, basically, got a lawyer and said, wait a second, we have a right to confer with the prosecutor. How can this happen? And the court said, you're right. You do have a right to confer. This plea doesn't exist. Now, again, for the lawyers in the room, there's a whole lot more that went on in that case because they end up saying, but we trust the trial court to get it right as it moves forward. So it's not the perfect case, but it shows that when victims have rights, if they have lawyers, they can make those rights a little more meaningful. Similarly, so those two were pretty early, and we were all thinking, wow, look at the good we did, right? Pat on the back. No. We have had since then some real challenges because once you start seeing impact, people push back, right? So we've had some pushback, but we have also had other positives. So State v. Barrett was in Oregon. So this was under state law, but it's very similar to the Crime Victims' Rights Act. And this was almost identical to Kenna, which is a victim had the right to be notified, present, and heard at a plea. This was a domestic violence stalking case. And the prosecution reached a plea agreement and went to sentencing without ever notifying the victim of the date. And that was undone for violation of victim's right. Very similar to Kenna, but at a state level under our state law, right? So a totally different judiciary also. In Re Hope Coalition is relatively new. This is a case from 2022 where defense was trying to get the mental health records of a sexual assault victim, which happens on a daily basis in the United States. And routinely, victims are not being told of these invasions of their privacy, or if they are told, they're told, well, the defendant's rights prevail. And I shake my head like that because that's the amount of legal thinking that is usually happening. Because as the judge said earlier, the law is the law. But what has happened in the US sometimes is when it comes to victims, the law is not the law. It's not treated as law until someone demands that it be treated as law. And so often what has happened is someone just says, oh, but the defendant has a right of confrontation. Well, in the United States, our jurisprudence is very clear. The right of confrontation doesn't even come into existence until trial starts. So that is a silly, silly legal argument pre-trial. But sometimes judges are like, oh, okay. Because, as the judge said earlier, the litigants aren't presenting the issues to them. The judges can only do so much. You need to have issues presented. And so in Re Hope Coalition, the victim again had a lawyer and presented a very well-briefed argument about the law. And it went up to the Minnesota Supreme Court, and the Minnesota Supreme Court said, of course the privilege matters here. Where pre-trial, you do not get to review the records, even in camera, meaning behind closed doors, right? But it never would have happened if it wasn't for the lawyers in the mix. That's been our innovation, right? So where are we going? One, we are continuing to review our victims' rights provisions all across the country to ensure that they afford standing, that they afford appellate review, right? Those are two things we have learned that we absolutely have to have, and then the icing is the cake to include a mandate that there be a judicial obligation to afford the rights. So we're having to revisit all of our laws to make sure they're there. Standing is the one that we are really making sure we have, and then we're moving to victim counsel, making sure that lawyers have access, we don't need access, that victims have access to lawyers, right? And we need to do that everywhere. I will say in my last minute, there are a lot of risks, and I don't want to hide from these, right? I will say with state violence in the US, mostly perpetrated by our law enforcement, they have started to claim the label victim. So they will claim if there's officer-involved violence, they will say, I was defending myself, I'm the victim. And so we are gonna have to grapple with that. Lack of victim lawyers means that we are leaving it to prosecutors at best to litigate victims' rights, which means we all have a state view of victims' rights. Some prosecutors are great at it, but some have a very narrow view of victims and their rights. So we need more lawyers. And then participation in a flawed system is always hard. We have a very racist system, and so engaging in that system in and of itself can be very challenging for some of us. But there are many opportunities. It is really beautiful when you can I call it the beautiful cacophony of victim voices. They don't all want the same thing, right? And it can sometimes be hard to figure out what to do. But when our system actually listens to all of the divergent victims' voices, our communities are better off. And so I think that's what we need. It can reduce trauma impacts and can resist prosecutorial gatekeeping if we have lawyers for victims. And so I will stop there. Thank you.